It's Gabby Rancifer, the law clerk here at Cascade Law Group, and I have another update for you. And again, it's regarding the CTA. So as we previously reported on December 26, 2024, the Fifth Circuit in the case of Garland versus Texas Top Cop Shop Incorporated first lifted and then reinstated a preliminary nationwide injunction staying the Corporate Transparency Acts, which I also refer to as the CTA, reporting requirements pending appeal. Most recently, the Fifth Circuit held that covered entities are not required to submit beneficial ownership information reports, so those BOIRs, to FinCEN anymore, though they may do so on a voluntary basis. The Fifth Circuit expedited the appeal and scheduled oral arguments in the case for March 25, 2025, so just a couple of months from now. Dissatisfied with that status quo, on New Year's Eve, FinCEN filed an application to stay the nationwide injunction in the Supreme Court of the United States. The court requested a response to the application by 4 p.m. on January 10, 2025, which is today. In its application, FinCEN asked the Supreme Court to stay the injunction pending resolution of the appeal to the Fifth Circuit, or if FinCEN loses in the Fifth Circuit, pending resolution in the Supreme Court. In the alternative, FinCEN requested that the court narrow the injunction in scope such that it would apply only to the parties in the case, as other courts in cases on the CTA have ruled. If either of these requests is granted by the Supreme Court, covered entities may be required to file their BOIR on short notice. Separately, FinCEN also asked the court to treat its application as a petition for writ of certiorari before judgment, which is a request for the court to agree to hear the case before a decision from the Fifth Circuit has been reached. It is unusual, although not unprecedented, for the Supreme Court to grant certiorari before judgment. FinCEN's application may be granted or denied by a single justice in this case. That would be Justice Alito, who is the circuit justice for issues that arise from the Fifth Circuit. Or it may be referred by Justice Alito to the full court. But whether considered by a single justice or the full court, the possible outcomes are the same. The first is that FinCEN's request for a stay could be denied, in which case the injunction would remain in effect and the CTA reporting deadlines would continue to be stayed. Alternatively, so this is option 2, FinCEN's request could be granted in the whole or in part. The court could then lift the injunction as to all covered entities, presumably triggering nationwide compliance obligations, or it could narrow the injunction to apply only to the parties to the case, in which case covered entities who are not part of the litigation would no longer be covered by the injunction and would have to comply with the CTA filing requirements and get those BOIRs in. It should be noted that President Biden asked the Supreme Court to let FinCEN enforce the law while the government appeals. Given continued uncertainty regarding when and whether the CTA filing deadline will be reinstated, you should carefully consider your options, and we recommend that you be prepared to file on short notice if the preliminary injunction is stayed, narrowed, or even vacated. Please note that Cascade Law Group does not provide advice as to the application of these laws to an entity unless we have been expressly engaged to provide such advice. If you are not our client, feel free to go to cascade-lg.com and click on Let's Work Together so we can come up with a plan to help you navigate these new CTA injunctions, injunction narrowings, and all of the sorts. See you later.